May it please the Court, the Board's order in this case should not be enforced because it is based upon erroneous legal foundations.
Look, I have to say, I do not understand your position at all. I don't understand why you don't want to permit this, investigator for the union to come in and spend an hour or two in the factory, looking around and trying to see whether she has any insights into the cause of the accident. How can that harm Caterpillar?
Your Honor, the question here is not whether...
No, you answer my question. How can that harm Caterpillar to allow the union rep to come in and look around? Are they afraid she's going to go into the business and competition with Caterpillar? Sell their secrets to other companies, or what?
Your Honor, I don't think that Caterpillar offered any of those reasons as why they were not allowing the investigator to come onto the premises. The first request from the union was to...
Would you just answer my question?
The answer...
Why is Caterpillar, what is the harm to Caterpillar of this investigator spending a couple of hours looking around?
I'm sure there's no actual harm to Caterpillar.
Well, if there's no actual harm, there is obviously actual harm to the union in saying that their investigator can't come in, because that makes the workers feel, well, the union isn't standing up for them, right? Look, if you have a death in a plant, that upsets the workers.
Yes, Your Honor.
Now, they have a union. They expect the union to be active in protecting them against workplace hazards. If the investigator isn't permitted to come into the building, the workers wonder, where's the union? They're supposed to be helping us avoid these accidents.
Well, Your Honor, the legal principles that govern non-employee access do not allow for such unfettered access.
Would you please give me a reason, not a principle, a reason why it is a harm? We know, I just said, it's a harm to the union and to the workers to keep this person out. Now, how is it a harm to Caterpillar to let her in?
Well, Your Honor, I think I've already conceded to you that there is no demonstrable harm to the company. And I think I've already...
Well, then I don't understand why you're here. Well, if there's no harm, what do you care?
Your Honor, the principles that govern whether or not access is permitted...
I don't understand you with your principles. If there is no harm to having this person here, and the union wants it, and I'm sure the workers welcome a demonstration that the union is interested in their safety, why is Caterpillar bothering to challenge the Labor Board's order?
Your Honor, the union's ability to demonstrate its utility to the employees is not solely dependent upon the ability of one non-employee to gain access.
Not solely, no, but it's important. We're not talking about the leaky faucet example that you gave in your brief, which was insulting to the memory of Mr. Smith. We're talking about a fatal accident in a dangerous factory.
Yes, Your Honor.
Now, I don't understand why, in that kind of situation, a reasonable application of the balancing test under Holyoke power would not essentially always call for access. With reasonable limits.
Well, Your Honor, it may be that ultimately, if the union had actually substantively engaged the company in a discussion about the circumstances...
Oh, you guys were playing games. Don't spend a lot of time on offers and counter-offers here. The question is OSHA had access, the police had access. They couldn't figure out what happened, right?
Yes, Your Honor.
Okay, so if you want to know, I assume Caterpillar would really like to know what happened in this accident, right?
I think it went to significant lengths to try and determine what happened.
Unsuccessfully.
Unsuccessfully.
So why not let Ms. Thompson give it a try?
Well, Your Honor, that's, again, with all due respect, I think that's what the company's efforts were trying to do, was to explore whether there was any benefit to having...
By limiting her to two-dimensional exposure, right?
Well, that wasn't
Watching films.
Well, that wasn't the only offer the company made to Ms.
No, but that's the critical difference, isn't it, between the access that she sought and what you all were willing to provide?
Well, perhaps, Your Honor, but that wasn't the only thing that we offered Ms. Thompson. If the record was that the only thing we offered Ms. Thompson was a single two-dimensional video.
That is not what I said. Nobody thinks that. But the critical difference here that is the point of dispute is, does she get into the plant to in essence see this in 3 dimensions, right?
Correct.
Okay. At the risk, I don't want to be flip about this, but I can think of an awful lot of situations where the ability to experience a setting, real dimensions, real speed, distance, is critical. Again, at the risk of being flip, if you watch a big league pitcher on baseball on TV, it's a very different experience from watching that pitch come in as you look over the catcher's shoulder, right?
It can be, sure.
Same thing whether it's football. Same thing. Picture yourself. What's the difference between hiking in the Grand Canyon and watching a film of the Grand Canyon? Would you agree there's a difference?
Depending upon where you're viewing the video, perhaps.
And if you've had the experience of being in the real setting to appreciate the dimensions, then you can also understand a film better, right?
Correct, Your Honor.
All of that leads me to think the ALJ was exactly right in thinking that there really is no substitute for actually getting into this scene where all of the other investigators were able to view the scene.
Well, Your Honor, the question of whether or not and when and under what circumstances Ms. Thompson could or should have been allowed such access was certainly something that we never discounted as a possibility.
No, you prohibited it.
Well, Your Honor.
At the time when it would have been most meaningful.
Well, it would have been most meaningful at a time when the processes were still in place. But by the time
she was there the next day, right?
Yes, Your Honor. And by the time Ms. Thompson the union offered some substantive explanation of its desire to be on.
Things had been changed by the time she arrived the next day, right?
Correct.
And you make a big deal out of that. Nevertheless, there was a second reenactment by the company about a week later, correct?
Correct.
Did you tell the local union officials you were going to do that?
I don't believe that the evidence shows that they were.
Why not?
I don't
Anybody think of inviting Ms. Thompson to that?
At that time, I don't think Ms. Thompson had made an additional request. The initial request.
Oh, come on. Obviously, she wanted to investigate the fatal accident, and you knew she wanted to investigate it. Your plant manager had checked with legal and said no. And then you're having another reenactment, and you don't even bother to tell the union?
Well, I believe the evidence is that there were members of the union that were involved in designing.
Members of the union participated. The question is whether you gave union officials, not line workers who were there to follow orders. Did you give notice to union officials that you were going to be doing this reenactment so that Ms. Thompson would have an opportunity to at least ask if she could come watch that one?
Well, I believe, again, we were aware of Ms. Thompson's desire to be on the premises, Your Honor.
And what rationale for not extending that invitation?
Your Honor, I believe at that point the parties were still discussing the circumstances under whether and when Ms. Thompson might be permitted on the facility. I mean, Your Honor, the law, the principles that govern this, you can look at any request for non-employee access to a facility and resolve it on the basis.
Non-employee.
We're looking at Holyoke Power.
Facility. This is a union official. This is not some passerby who says, "Oh, I'd like to look inside your plant, see what you do there. I'm curious."
Well, Your Honor, the law, Leekmere and the balancing test in Holyoke and numerous
others. Yeah, but you know, the problem with the balancing, your problem is there is nothing on your side of the balance.
I just respectfully disagree.
Well, all right, tell us, what is that's my initial question. What is the potential harm, cost, burden, what have you, to Caterpillar of allowing her to look around?
There is no palpable harm, Your Honor. But
then how can you have, if you have a balancing test with 2 pans, one of them is empty, yours is empty, and now how is it that your pan is going to outweigh the one that has weights in it.
Well, because leak mirror does not turn on whether or
Now
not...
you tell me what is balanced.
So what I think you're about to tell us is that you're relying entirely on the suggestion that leach mirror should be extended to safety inspections as distinct from organizing efforts. Is that right?
I believe that that's correct.
Has the Supreme Court taken that step?
I think the way in which it describes...
Has the Supreme Court taken that step?
It is not, Your
Has
Honor.
any circuit court taken that step?
Not that I'm aware of.
Has the NLRB taken that step?
Yes, it has, Your Honor.
When?
I believe that the Success Villages case we cited, Estonia Village, Leslie Holmes, are cases that consider the application of leak mirror in the non-organizational context.
Do any of them have anything to do with safety and health inspections?
They do not, Your Honor. But
Okay, so what you're asking for is a real novelty then here, although you haven't acknowledged it. Instead, you're telling us this is all perfectly obvious and that the NLRB, and that access for the union officials in this situation is a, quote, last resort, right?
Yes, Your Honor.
Has anybody else ever used that phrase, last resort, besides your reply brief?
I believe that the upshot of leak mirrors holds exactly the same, Your Honor, that the balance that is to be struck assumes that the employer's property right will predominate except in exceptional circumstances. I'd like to reserve the rest of my time for rebuttal. Thank you, Your Honor.
Okay. Thank you, Mr. Torres.